to make changes to achieve that compliance. As of May 25th, 2018, the regulation will become law, and then will go into full effect. So, organization not in full compliance with this regulation by that date faces heavy fines and sanctions. GDPR applies to both companies based in the EU as well as companies worldwide offering goods and services to people based in the EU or monitor the behavior of the individuals within it. Failure to be in compliance can result in fines which are the greater of 20 million euros or 4% of the making's worldwide turnover. This is a short list of steps on the road to GDPR compliance. I'll read through these, and then we're going to get more detail on this for the rest of the presentation. So you need to review and document data processing activities and security measures. Execute a GDPR compliance roadmap, data protection impact assessments, review existing vendor contracts and privacy policies, determine not you need a data protection officer or DPO, talk about what the DPO responsibilities are, look, you can or want to set up a one-stop shop, and mostly, of course, inform, stay informed, and enforce. So the first step towards compliance is review and documentation of your activities. You document all data processing activities, identifying the what, where, when, and why. This also includes the processing of client and employee data. Review and documentation of expected consequences of the process, and this by conducting a risk analysis for every process. And a tip, you should gather different departments of your company to ensure that all data processing activities are covered. This is a list of questions that can help you in the process when you're documenting your data. Information is given before collecting and processing your data. Whose data are you processing? What is it? Where is it processed? When processed, and why is it processed? Do you have a basis for processing data, and is it in accordance with the data processing principles? What is anonymized, and what data is pseudonymized? How the data? Who you share the data with? What is the level for each process? In which is your business a controller, a processor, or a joint controller? Are any data what any member state would consider personal data? That would be something that contains an IP address, ID, a cookie, or any sort of online identifier. Processing of data for security reasons. So be sure to document the specifics. And are you currently receiving or sending consent signals along to your processors and or third parties? Please consider that any personal data stored or sent outside of the EU will need to follow the cross-border transfer rules. It can be found in Chapter 13 of the GDPR.
Hi, good afternoon. This is Juan here, and I'm going to talk to you briefly about data controllers, data processors, and joint data control. I'm referring to specifically the articles in the GDPR 24 through to 29. Not go in any great depth into the articles, but these are the articles that cover the aspects that we're discussing now. We'll start off by establishing that GDPR compliance is probably going to mean that you have to be conscious of both recipients of your data and who you're receiving data from. And correctly, you're within the data flow lifecycle for the industry sector and ecosystem. Doing this, complexities are going to arise. Most of your affiliates and partners will always want to take the least data-intensive role that's available to them. People will want to become a data processor as opposed to a data controller wherever possible. You're conscious of where you fit within any data life cycle. and you correctly assess and identify your role within that data life cycle. So as we move on, I'm going to further to discuss what kinds of complexities you might face in identifying your data role. If you change data in terms of receiving and processing it, likely to have changed the data roles. If you receive data, the data processor, and enrich that data as part of the data processing activity, we create a new data product in which you will change data roles. You would have switched from a data processor to data controller. What you would have to do is go back to the GDPR and check what responsibilities have now changed to. Mostly discussing these terms with you, but you should be conscious whether at any stage in the process they are changing data roles. As you move on, you should be conscious of what the requirements in the data role become. You may start it off as a data controller, change to a data processor, and change yet again to a control when you enrich data. In achieving compliance with the GDPR and to achieve that compliance, you should be conscious that the means of your compliance is likely to be in terms of your following the process attributes that are required of you under GDPR. On slightly to talk about some of the security concerns and how you assess and measure your security under GDPR. The key point to identify would be that you need to identify a suitable framework that you can use to implement your GDPR compliance. GDPR as in itself does not provide this framework. It is a legislative entity. It is a set of rules and governance criteria that determine how you should process data, but it does not provide you with the framework to achieve or measure your data compliance. You should do this yourself. You should identify a standard or a set of standards that are recognized across the industry, apply those, and keep always in mind that GDPR is the end goal. So application of those standards, you're conscious that you're doing so in order to achieve GDPR compliance. The privacy management framework. This will be a reference to the GDPR that enables you to take privacy management activities and assessments that you've made in terms of your data privacy and refer back to the GDPR where you need to. A management framework could be the key to achieving GDPR compliance because it will always keep you conscious of those articles within the GDPR that you need to adhere.
Step you should be taking is to create and execute the GDPR compliance roadmap. Data processing and security reviews and assessments should help identify activities which could be conflicts with the GDPR and therefore require changes. We create and execute the GDPR compliance roadmap. To ask during the creation and execution phase of the GDPR compliance roadmap, in what way do your current processes conflict with the GDPR, and are there changes you can introduce to solve this? To make necessary changes. Do data on the basis of users' consent. Do standardized methods to receive and pass on consent to third parties and processors. Do additional logs. And an example of this would be is if data is being processed on the basis of users' consent, you likely will need to record this somehow with a timestamp when consent was given, not given, or revoked. Connect that to the IP address, cookie, or online identifier, or UDID. This is your due diligence later in terms of compliance. Users' right to access and other data subjects' rights and maintain your proof of compliance. This is Chapter 3 of the GDPR, Articles 12 to 22. And to work with your processors and sub-processors to create documented instructions on the handling of data, otherwise known as data processing agreements. It requires data controllers to carry out impact assessments to any new data processing activity in any of the following cases: where technology is used, when it's likely to have high risk for data subjects. You can do impact assessment for multiple processing operations as long as they present similar risks. When it involves a systematic and extensive evaluation of personal aspects relating to the natural persons, which is based on automated processing and profiling, and on which decisions are based that produce legal effects concerning the natural person or similarly significantly affect natural person. Access a large scale of sensitive personal data. Systematically monitor a publicly accessible area on a larger scale. Pay attention to the work of supervisory authorities. They are tasked with establishing a public list of processing activities which require a data protection impact assessment. They also choose to publish a white list of processing activities which do not require a data protection impact assessment. In amending your contracts and policies, changing your internal processes is really only part of the compliance journey. Another aspect is to ensure that these are reflected in contracts you have with partners. This is the GDPR requires you to have specific agreements in place with companies you work with, such as when your company and another company are considered joint controllers. The data controller is the one which determines both the purposes and the means of processing of personal data. So these companies must review already existing vendor contracts and their own privacy policy. It recommends that you review all vendor contracts and amend where necessary. And when dealing with multiple data processors, an arrangement between joint processors must be created to assign data protection compliance responsibilities amongst themselves. Also, review your terms and conditions. Review your privacy notices, your external disclosures, and your privacy policies, your internal rules. Rules and procedures in place for employees who work with personal data and document them in privacy policies. Data must be provided with certain information about the collection and further processing of their personal data. As stated in GDPR, this information must be provided in a concise, transparent, intelligible, and easily accessible form using clear and plain language, usually in the form of a privacy notice. A arrangement of joint controllers needs to be made available for data subjects. Consider using tools or software to monitor that third parties act in compliance with the agreed upon contracts and privacy policies. There are a range of market solutions to data leakage, including tag management solutions, privacy tools, and data loss prevention tools. On a data protection officer. It requires companies to designate a data protection officer if none of the below requirements are met. If the member state requires it, if the company's core activities consist of processing, which require regular and systematic monitoring of data subjects on a large scale. Data processed is sensitive information, revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, membership, genetic data or biometric data, and data concerning health or natural person's sex life or sexual orientation. That in the diplomatic industry, most industries and most companies will probably find themselves needing a DPO under the second point here. was formally tasked with ensuring that an organization is aware of and complies with its data protection responsibilities. DPO has expert knowledge of data protection laws and practice and should be able to perform the following functions: informing the relevant controller or processor, the employee who processes personal data, about obligation under the GDPR, compliance with the GDPR by a controller or processor, impact assessments, engaging in prior consultations with the data protection authorities or EPAs, cooperating EPAs and acting as the point of contact, all data protection matters affecting the controller or processor properly and in a timely manner. The control processor must provide the DPO with the necessary resources and support to do this. Establishing a one-stop shop. One of the potential benefits that the GDPR provide is for companies is this concept of the one-stop shop. This applies to organizations with multiple establishments across the EU, as it allows them to designate a lead supervisory authority and uniform application of compliancy across all member states. Or operate in multiple member states will need to carefully consider their options in relation to establishment of the one-stop shop. The organization has establishments in multiple member states and established the one-stop shop. The DPO for its main establishment will be its lead authority, and this authority has the power to regulate that organization across all member states. In order to qualify for a one-stop shop, the organization will need to have a headquarters or main place of establishment in the EU. Having a one-stop shop and a lead DPA as a single point of contact, as opposed to multiple DPAs and multiple member states, will allow for a more uniform application of compliancy and authorization on compliance of the data protection. You can see there's a link. This link goes to a website which lists all of the DPAs across the member states. Staying informed, being informed and enforced about employees first. So really should inform and train your employees about the implications of the GDPR and data privacy and your new privacy policies on their work. And make sure that respecting your policies is enforced through appropriate disciplinary actions where necessary. Stay with industry initiatives and standards by joining and engaging with IAB Europe and IABs in your respective markets. Other companies that are looking to hold initiatives on the GDPR. A good example of this would be the IAB Europe GDPR webinar series. This is just the first one of many more that will kick off in the coming months. Also, Improve Digital is planning an in-depth practical workshops on the GDPR implementation within the context of the advertising ecosystem. So if you're interested in that, please send us an email and we'll reach out to you as soon as possible. You can marketing at improvedigital.com for that. Follow Article 29 Working Party, the European Data Protection Board of the future. And also follow the work of data protection authorities in markets in which you are active. It is important to your business partners that you're informing them in a timely manner of any changes you make to your products or services as a result of your efforts to comply with the GDPR. This organization is consumer-facing. They also need to be informed of updated privacy policies, particularly when it comes to using consent as a legal basis for personal data processing. It's extremely vital that new processes are in place are communicated to all parties involved. So again, inform employees, processors, users, and clients well as May 25th, 2018, of changes to terms and conditions and privacy policies. And informers, processors, sub-processors, joint controllers of all the necessary contract changes. There's no way around it. As of May 5th, it's law, and you need to be prepared. And you haven't started yet. You need now, today. And as a quick, just where this is and what's happening, this opens up. This is down. When I started this countdown, I just want to note that we were at, I think, 90-something days, and now to 238. Okay, that's all for the presentation.
Thanks a lot. So I'm just going to explain to the rest of you, which I should mention at the start, is that at this point we're open for questions. If you look at your WebEx client, you should have Q&A section. You can type your questions there. I'll read them out to Michelle, and then between us we'll try and answer them as best we can. Just to get started, I have a question here from Hubert Gall, who asks, what exactly do you mean with a one-stop shop? Maybe you could clarify this, Michelle.
So basically, GDPR is a thing called a concept of a one-stop shop. What this means is that, so basically you're an organization and you operate in multiple countries within the EU or multiple member states. If you were not using this one-stop shop thing, you basically would have to many different data protection authorities for every member state. So if you had offices, say, in the Netherlands, in Germany, and the UK, then you need to have someone in the UK dealing with the UK authority. You need somebody in the Netherlands dealing with the Dutch authority, and some in Germany with the German authority.
Come in here as well for a brief while, in that within each EU state, the GDPR is mandatory, but the application of the GDPR may vary from state to state, and states may also put their own legislation above and beyond the GDPR. So a one-stop shop provides organizations who are spread across various regions the opportunity to deal with one data protection authority as opposed to each one individually.
Okay, another question, and I'm hoping that this is a little bit tongue-in-cheek, but someone asks, how do we get the GDPR repealed? So I'll just answer it since I work in the policy team at IAB Europe. It's not very likely that it will be repealed, so you have to deal with it no matter what, and it won't be repealed in the next 6 or so months until, was it 8 months until it comes into force. Just as an aside, I did see a question earlier that mentioned the e-privacy regulation. Just to note that that's also still in the works, and the initial intention was to have that come into force at the same time. But due to the legislative process in Brussels being extremely slow, it's not likely that they will hit at the same time. But in terms of the GDPR, it is coming, and we have to face it as an industry and do our best to rise to the challenge. I see a question here, which is quite a loaded question from Alan Chappell. Is limited interest a viable option for companies participating in the programmatic advertising marketplace? With that, Michelle or Vaughn?
Legitimate interest is listed in the GDPR as a possible lawful means for processing of data for digital advertising. How I would always caution anybody to exercise extreme caution when assigning legitimate interest to their lawful processing of data. If used to opt for legitimate interest, the Protection Authority is probably going to look a little deeper at relationships with other data processors and data controllers, and they want to see some more intensive governance of your data processing activities. The second thing is, everybody should take note that while legitimate interest provides you with the initial lawful means for processing data, a user's right can override legitimate interest at any time. So if user opts out, your legitimate interest, in effect, falls away. And the people always remember that at any point, legitimate interest can be overridden by user rights.
Thanks for that. I have another question here from Marcin Kshimin. I'm not sure how to pronounce your last name. Sorry. And he asks, are there any guidelines that would advise me as to whether my company handles personal data or not? It seems to me that it's crucial to learn that in order to correctly prepare for the GDPR. So this is a very good question, actually, which also also gives me the opportunity to promote our next webinar in the series, which is exactly on this topic, the definition of personal data. As you know, GDPR applies when you're processing personal data, so the distinction is very important. And in the GDPR, the definition is extremely broad, and in our second working paper, which is already published on our website, we try to explain where there are boundaries, if any, for this definition, as it's a definition that does not allow you to create a sort of list of what falls within, what doesn't fall within personal data. It's a very context-driven definition, and in each case, you'll essentially have to on your own level if something is or is not personal data. So this is something we'll discuss in more detail in our next webinar, which it looks will happen in the first week of November. So an eye out for that. In the meantime, I would direct you to check out our website, iabeurope.eu, where we have a paper which explains the definition. I have another question here from Tomai Karu. Can you describe how the end state looks like for an ad tech company and publisher? Not exactly sure what this. I'll just, does that sound like anything you know how to answer, Michelle or Vaughn, or should we just go to the next question?
Okay, well, it's a bit of a broad question. An end state publisher. Compliance in this case would look like a clearly defined data flow map that they would need to know all the entities they pass data to and receive data from. It would be a series of compliantly drawn up data processing agreements, establishing the roles between these affiliates. The publisher would have to take on the role, generally, of the data controller, and they have to define that role and purpose for processing data. They will have a property management framework of their own in place, which map the various aspects of their compliance program against the requirements of the GDPR. Then they would have their one-stop shop, whereby they contact the Data Protection Authority, they set up a channel for data breach notifications, and they also have a method for establishing conformity with their respective Data Protection Authority.
For that, Vaughn. I have a question, which is a follow-up to the earlier question about a one-stop shop, which asks, how is it possible to have different GDPR rules in different countries? Rules are rules, but essentially the point of a one-stop shop is to avoid any kind of difference, so that you organize all your data protection needs as a company that is based in several countries just on one end, so that you only know that your data protection compliance has to be good enough to satisfy one of the DPAs, the one that you choose as a one-stop shop. So, as well from Daniele Paganini, which says, reselling customer data collected via a DMP to DSPs, third-party data, how to comply to the PR as they are not sensible data. I think what you're getting at is the problem that you might not have a direct relationship to the persons whose data is being processed. This is an issue that we are trying to figure out as well, how to get consent for the processing of data when you don't have a direct interaction with a data subject. Essentially, the answer to that is that the whole industry has to kind of work together to make sure that it's properly communicated who in the chain is using data, so that the data subject in the first place is aware that their data is being processed by these companies, and secondly, that those companies know that they have the consent. Michelle or Vaughn?
think I would add too much to that, in that all I would say is that each entity in the chain can develop their own consent management process. So ensure that your trade affiliates and your partners send you indicators of consent having been gained.
Okay, thanks. A question here from Jan Jelek, who asks, how many users will be a large-scale user? So I'm guessing this speaks to the definition of large-scale. For the Article 29 Working Party, their definition of large-scale applies to a lot of things, and I think in general they mention specifically online behavioral advertising as an example of large-scale processing. It's not necessarily pure numbers of people whose data is being processed, but it's also the amount of processing happening and the scale of it. So in terms of online behavioral advertising, the fact that it takes place over the internet, over multiple websites, this is already considered large scale in the eyes of the Article 29 Working Party. For those of you who don't know, that is the UN level sort of group representing all the data protection authorities in the member states. So while they are very strict on their reading, they also represent quite what they will be thinking when it comes to enforcement. So even if it seems a bit extreme to us at times, needs to be taken into consideration. Alan Chappell, what are the core considerations for data processors regarding access requests? If a data subject places an access request to a data processor directly, should they respond? So I think I could answer this. Well, I can't answer the question of should they respond. All I can say is that currently this is an issue that we are also thinking about heavily. We're having another working group within our GDPR group that's trying to figure out what kind of recommendation to give. If the request comes directly to a processor, that's interesting because you have both processors and controllers, and the processor, in theory, should refer this question to a controller, is my feeling. I don't know if you feel differently about this, Spawn. But I worry that maybe this question is a bit more technical than some of the people might be interested in.
I pretty much feel the same way, that always the data processor should adhere to the governance directed to them from the data controller, because the data controller really determines data processing activities and provide data to a third party without the consent of the data controller would actually put you in non-conformity with the GDPR. So you should refer in that case to your data controller. The other is you would need to validate that the person requesting the data is legitimately of the data. So you would have to acquire personal data in order to assess that they are indeed the true data subject. It would always be best advice to refer back to the data controller.
Okay, thanks for that. I have another question here from Petri Kokkonen. Could you recap shortly when we need opt-in and when opt-out is enough? I missed the beginning of the webinar. Yeah, so that part isn't necessary, sorry. So I think when you think of opt-in and opt-out, essentially the distinction you're making is between whether you need consent for data processing or whether you need to use the legitimate interest. Essentially, this is a question that we wouldn't like to answer beforehand, because the legal basis that you use for processing personal data depend very much on a case-by-case basis, depending on what kind of processing you're doing. But in general, our feeling is that consent is the more likely way to get a legal basis for processing personal data, which will mean opt-in in most cases. And the reason for that is actually separate from the GDPR, but there's this legislation called the e-privacy directive and the e-privacy regulation, which is currently being drafted and is the updated version of that law, which is consent for the storing of cookies, but also other interactions between a browser and a user. And in most cases, there will be an interaction such as the placing of a cookie or between user and the company. Consent is required already for that, and for that reason, in most situations, it makes more practical sense to get consent beforehand. Maybe Yvonne has a different take on this, but I'm just explaining a more policy-related reason why we don't really feel like opt-out is a safe way to go.
So I would recommend that wherever in the EU, always go for opt-in. And add on to that, it's always safest to ensure that you do have consent. Regardless of what lawful grounds you utilize for the processing of data, try to always measure that in terms of consent.
Okay, and so I have two questions next to each other, which are actually sort of similar. So the first one asks, what would it mean for a publisher to be compliant with the GDPR? And the next one asks, for digital publishers, are you aware of any frameworks that are being developed to aid publishers in capturing user consent across many partners? So, you know, I think the second question almost answers the first one in at least one aspect, and that is the aspect of consent. So the publisher is the one who faces the users or the data subjects, as the GDPR calls them, and it is to them to capture, so to speak, the consent and it. In terms of a framework being developed, this is something that we are also trying to work on at IAB Europe, at a few different methods through which it would be possible to send consent, not just for a specific purpose, but also for companies. The trick is managing that in a way that stays user-friendly and usable without overloading systems, and also being able to take into account the entire system that is involved in a specific case.
Quickly, so on a very general basis, I think when you're talking about publishers, yes, they are the first contact with the user. Users are going to their website, so they have to receive that consent signal. They have to offer the option to the user, and they have to opt in. And then they pass that consent signal to their technical providers. So in our cases, what we're looking at is doing a two-pronged approach. We're going to put in with our contract and talk to our publishers and say, only send us the bid request when you have consent, when you have that opt-in value. And then when you don't have that opt-in, when they haven't opted in the EU, don't send us the request. But next to that, we still need to perform due diligence. We can't just go with that, and neither can any local provider. We really also need to build something to ensure that they're doing some kind of checks, such as logging when you receive that consent, when the user's opted in, when the user's opted out, et cetera. There's really parts to it from a technical provider perspective.
Yeah, I mean, I was mostly focused on the issue of consent, but of course, within every company, when the GDPR comes into force, you will need to be data protection compliant. So, sorry, some other phones ringing here. Okay, the next question I have here is from Grashina Jurkiewicz. The question, if a one-stop shop is set up in a UK subsidiary, will it still be recognized by the EU authorities post-Brexit? So this is an interesting question. I really give you a definite answer. I can just speculate what the answer to this would be. I'm sure if the UK's Data Protection Authority remains a member of the European Data Protection Board, which is the European level conglomeration of the authorities. I know that the intention is to have essentially the same data protection law in place, but this is only so that they can that they have an equivalent level of data protection and have data transfers be recognized through some kind of what's the name? An agreement such as the Privacy Shield, an privacy decision, essentially, is what it's called. But it would make more sense in that case to find one of the EU 27's authorities to establish a one-stop shop to be on the safe side. Question from Mitos Economou. How do authorities choose which company they will check for GDPR compliance? That's something that I won't be able to answer. I mean, that's what the authorities will do. Essentially, my feeling is that there are a lot of companies who are not completely GDPR ready by the time we hit May 5th, 2018. But likely, it's their choice who to prosecute, essentially, and who to go after. A lot of people speculate that this will be big American companies established in Europe, so think of Google, Facebook, Microsoft, but it is up to them, essentially. As an example, for the cookie directive in the Netherlands, the directive was enforced quite strictly, and an example, they went after the public broadcasters' websites before any private companies. So it's really up to the authority. Yeah, so there's another question from Jan Jelek. What about audience measurement? Say to that, Vaughn or Michelle?
So I'm not quite sure in regards to what that question is referring to. Audience measurement.
That's true. Yeah, so audience measurement, suppose they're in the same vein as what would a publisher need to do, what would an audience measurement website company need to do for GDPR compliance?
Okay, so this breaks down to the same thing. Identify your data flows, and when I say identify them, I wouldn't put the terms of just looking at what data we receive and send out. I refer to it in terms of documenting your data flows. Identify the trade affiliates that you're with. Identify your data role. Are you the data controller or are you the data processor in relationship? Document and contractually obligate your partners to their data processing roles. Put in place a framework that allows you to address each one of the GDPR articles directly, specifically pay attention to those that directly apply to your business. So data controller, there would be specific articles within the GDPR that apply to you and specify your responsibilities as a data controller, like if you were a data processor or a joint controller.
Okay, there's another question here from Christina Corbu, which I think the answer is going to be similar for, which says how we see the GDPR compliant functioning of a data management platform, which was first, second, and third-party cookies.
I'm going to put on my auditor hat now because that was my previous career, and I'm going to discuss this in terms of what I would be looking for if I were an auditor visiting any one of these sites, whether it be a publisher, an advertising measurement organization, a data management provider, DSP, SSP. And what I'd primarily be looking for is their application of the requirements under GDPR and the audit trail that they create in the application of those requirements. So we're going to be putting in place data processing agreements where you've got an audit trail that shows how you measure and assess those processing agreements. If you're basing your lawful means for processing data on consent, make sure you have auditable records that show how you gather and manage consent. And remember, when it comes to consent, that you would also have to record cases where you don't achieve consent. So in order to be compliant, yes, you will record where you receive consent and continue to process data, but you also record where you didn't receive consent, and so you didn't process the data, and you have to be able to show that to the protection authority. The next thing is you would have to comply, every organization is have to comply with two concepts under GDPR. The first being privacy by design, and the second being privacy by default. It means that in your day-to-day work processing activities and within the activities of your organization, you have to build in the structure to measure privacy concerns and compliance with those privacy concerns on a day-to-day basis. So it wouldn't be a case of, okay, let's continue working as normal, and then at the end of the month, we're going to go back to have a look, have we met all of our compliance requirements? It would have to become part of your normal working process.
Okay, this is especially a very good point at the end, that it's not something that you can check in on. It's something that you have to continue to work at, and you have to make it the base of a lot of your processes. A question here from Petri Kokkonen. Is there any example website which could present a basic website carrying basic ad tech and data tech, which would be GDPR proof? I don't know of any. Have you heard of anything such as that?
No, I haven't. And for the audience, at the moment, there still isn't any GDPR seals or GDPR approvals. That is for the future, but there's no certification that you can acquire right now that will provide you with GDPR compliance. That may come about in the future, and we may find that we start getting codes of conduct published by organizations, but presently there aren't any. So in terms of answering that question, I couldn't say it at the moment.
I agree with that. Also, as a matter of law, since the GDPR is not enforced yet, it would be possible to say technically whether somebody is or is not compliant until it starts being applied by the authorities and by the courts. So I have a question here about cookies. Does a cookie-only collection still require an explicit user opt-in if no personal data is linked to that identifier, including that of an IP address for EU users? So I think what the question is asking is, do you still need an opt-in if you're collecting data with a cookie as linked to an identifier such as an IP address? Just to first, before I let you speak, identifiers can be and are considered personal data under the GDPR, so that would trigger the application.
Yes, on IP address. As far as we know, Germany, IP address is personal data, and that would fall in the GDPR also as personal data. So, as personal data is defined as we see it as any online identifier, so a UDID, a cookie ID, an address, a device ID, ID. Any of these things really is personal data under the GDPR. We're not talking about names and email addresses. And the big problem with this, of course, is if you're getting consent, if you don't get an opt-in, think of it, you can run a programmatic auction. I mean, can you run a programmatic auction if you're not putting through the IP address or cookie ID? Well, no one will buy. It's a big risk for what's going to be happening on May 25th of next year.
Yeah. So just to come back on what I mentioned earlier, our next webinar will be on the topic of what personal data is and what personal data isn't. And we do have a paper online which explains the new definition of personal data, which you can find on our website, iabeurope.eu. The next question is, how specific does consent need to be? Meaning, how much info on exactly what you are using the data for is needed?
So the GDPR insists on total transparency. So you need to inform any user that's providing you with consent exactly what you're doing with their data. And to be clear and concise about this, because the definition of consent with GDPR states that it must be informed and without detriment to the user. So considering those two key words of informed and without detriment, I'd say inform your users completely about what you're doing with their data.
Thanks for that. We have a question here from Jennifer Mylander. You previously discussed the GDPR's legitimate interest. How does e-privacy regulation deal with legitimate interest? Would you say that? Because I don't know how up to date you are on that.
Yeah, well, you go ahead and answer that first, Chris.
Okay.
Although I wasn't in your last session on e-privacy.
The short answer is there is no legitimate interest in the e-privacy regulation. To have any kind of interaction with the user's device, you need their consent. And this has been something on the policy side that we've been lobbying hard for, but there doesn't seem to be much hope in terms of the opportunity to get a legitimate interest introduced under the e-privacy regulation. The European Parliament is close to finding a position which does not have the legitimate interest. It's consent or nothing. Another question here. Can you speak to approaches to pseudonymizing personal data, and in particular for identifiers? Is IAB Europe looking into this? So just to answer that last part, we're currently not looking at how to pseudonymize personal data. It is something that do in the future, but at this point, when consent is seems to be the way forward, it is something that we leave to the companies to figure out for themselves if they feel it's worth.
Maybe add to that.
Pseudonymized data is still considered personal data, so
exactly.
You would still need to achieve consent for the processing of that data. In short, you could say that any data that can be linked back either directly or indirectly to a natural person is considered personal data.
Okay. I have a question here from Charles Simon. Do you anticipate any kind of grace period as the GDPR takes effect? It seems like a tremendous amount of subtlety can only be defined as regulators start acting under the law. I just want to say, first of all, to this is something that we've experienced when talking to regulators as well, in saying that something unclear and needs to be figured out, and the answer has been a few times, you'll just have to wait for a court to define it more specifically. In terms of an official grace period, there was supposedly 2 years between when it was adopted last year in 2016 and now. For companies to get ready, but there are subtleties which, are still unclear until we have a definite I'd
like to add to that as well, Chris, if I can.
Yes, please do.
Within my own field and in attempting to apply GDPR compliance within our organization, I am also acutely aware that in college not too far away from our office location, members of the Data Protection Authority are currently undergoing training courses how to audit against this. So I do not suspect that there's going to be any grace periods for anybody, and I would suspect that not only in our country but across Europe, staff from data protection authorities are scaling up and are skilling themselves to be able to audit for GDPR compliance.
And to clarify for those of you who are unaware, Improve Digital is headquartered in Amsterdam. So speaking about the Dutch Data Protection Authority. We have one more question here in the Q&A box, but I see a few in the chat as well. So this last question is, can you flesh out what is necessary to document that consent has been I think, passed on from vendors and data processors.
Okay. How you document consent would depend specifically on your data flows. I can tell you that within Improved Digital, we're going to be looking to document consent that's provided, a timestamp of when consent was provided, certainly the publisher, and even down to the site level that consent came from, the on country of the consent was gained from. And this will relate to whether this is an EU national or EU resident or not. But I would say be as granular as possible when recording your consent, because that consent can be withdrawn at any time. And you need to be able to show that your processing activities happened when you had consent, and the minute consent was withdrawn, stopped processing the data.
Looks like I think just have one more question now, which is a quite interesting one, which asks if the only scenario where user rights would be prioritized above a legitimate interest is when the user opts-out, or are there other scenarios? So you could explain a bit how the legitimate interest works.
Legitimate interest is a very loose definition within GDPR. And it states where an organization is able to establish that they have a legitimate interest to continue processing the data. Now, rights will always override legitimate interest. It's not only where consent is withdrawn, but any one of the user rights that are provisioned under GDPR will always override legitimate interest. So, in short, you could say that if you're going to claim legitimate interest, I back it up by gaining consent as well.
Okay, I don't see any more. So their follow-up question will say that opt-out is a scenario where it applies. Processing of personal data for direct marketing purposes may be regarded as carried out for legitimate interest. That's
I provided that example because once legitimate interest is provisioned there, you have to be conscious that if a user opts out at any stage, you then have to stop processing their data. I could be processing a user's data under the auspice of legitimate interest, but I still have to provide facility for that user to opt out of my processing activities. And if they ever do opt out of those processing activities, I have to make sure that I adhere to that opt-out option. Does that question?
I think please do keep in mind that we are speaking about an hour now. I did interviews for 1.5 hours, but we're not really getting any new questions in. If any further questions, please feel free to reach out to me. On some more housekeeping items, we will send a PDF of the presentation that we saw at the beginning round, together with a copy of the GDPR compliance primer. That's the document version. As a link to, I think it might be important, a link to the personal data paper, which we have on our website. I'd like to thank Michelle and Vaughn again for coming in to present this and answering the questions very gracefully. Thanks for joining, and to see some of you or most of you back at the next webinar, which will take place in November.